Have you received an unfavorable order from the Indian Patent Office regarding your existing patent application? There are chances that you are involved into an opposition proceedings, or you are involved in a compulsory license matter and you are aggrieved by the final order or decision of the Indian Patent Office. What are your chances of turning this unfavorable order into your favor, and how you can do it? I am going to discuss these details, these various instances where the patent applicant or any interested person who is aggrieved by the order or the decision of the Indian Patent Office can file an appeal before the appropriate forum. I will going to discuss in detail what are the various timelines, how you can file it, where you can file it, and what are the various facts and circumstances you must keep in your mind in order to secure a successful appeal order in favor of yourself. So let us now go deeper into the appeal process, and let's start firstly with the patent examination process, because जो सबसे ज़्यादा bunch of appeal matters जो आते हैं वो primarily इसलिए आते हैं because the patent applicant is aggrieved by the decision of the learned controller of the Indian Patent Office and is not satisfied, and that's why the patent applicant intends to challenge that particular order. So let us have a quickly go through into the details of examination process in India. Okay, so typically in India the examination process starts by filing a request for examination, which is around 31 months from the earliest priority date in India. So once you have filed the request for examination, the patent application will sets into a queue from where the application is assigned to a patent examiner. The patent examiner is going to analyze your patent application on majorly two fronts. One is the procedural, and second is the substantive provisions, right? Substantive provisions. So in the procedural aspects, we normally, the form 1, let's say in procedural aspects, it may be certain objections like, the power of attorney was not submitted in timeline, form 1 was not submitted in appropriate time. Whereas in the substantive questions of law, the patent examiner is going to examine your application on the novelty aspect, on the inventive step, then on the industrial applicability, so that it ensures that your patent application becomes in accordance with the requirements set out by the Indian Patent Act 1970. Once the examination is completed by the patent examiner, the learned controller reviews the examination report and issues the formal the examination report in the form of FPR, which we called as a first examination report, and it includes all the official objections. Okay, the patent applicant has a statutory timeline to respond to this objections, which is typically firstly 6-month timeline and then additional 3-month timeline. So effectively from the date of receipt of the first examination report, the patent applicant has overall 9 months to file the response to the examination report, as well as to ensure that within 9 months the patent application has met all the mandates of the Indian Patent Act. And during this process, agar patent applicant intends to appear before the learned controller for personal hearing also, then the opportunity of being heard is also given to the patent applicant, in which the patent agent or the patent applicant on its own can appear before the learned controller and try to address the the objections which are still pending in the hearing notice. And finally, once you appear before the learned controller during the hearing and further submit your written submissions before the learned controller, then the learned controller is going to examine your response to the first examination report, response to any further examination report if issued by the learned controller, then the written submissions submitted by the patent applicant. Based on all these documents, the learned controller is going to issue the final order. The final order can be in your favor also and can be against. And if it is against, right, you mean, for example, it could be a rejection of your patent application, right? It could be a rejection of your application. It could be a rejection of your scope of amendments in the claim. It could be reducing the scope of your claims also. So in various circumstances, when you are aggrieved by the decision of the learned controller, then the window for appeal is open to you. Okay, window of appeal is there, and we are going to firstly discuss what are the normally common reasons of rejection. We are going to discuss now, so that you get a fair idea that what are various circumstances where you can approach the next competent authority to file an appeal against the final order or the decision of the learned controller. So let's now move forward with the common grounds for rejections on the substantive issues. So this list which we are going to discuss, it's not a comprehensive list. It is just going to give you an idea what are the various common grounds of objection which you received from objection to rejection, right? Objection is at a stage when the learned controller gives you opportunity to submit your response. But rejection is after considering your response, the learned controller is of the view that you still did not meet the requirement as mandated by the Indian Patent Act. So he is going to reject your application on the basis of XYZ reasons. Now, first of all, if you see, in major of the applications, we generally receive, the invention lacks the inventive step, the section 21JA. Okay, we will see in the final orders that typically, the invention is considered obvious to a person skilled in the art. Such kind of language would be used by the learned controller to reject your patent application on the basis of section 21JA of the Indian Patent Act. Okay, what does this mean is, critically I generally communicate to the clients or to other stakeholders that the learned controller believes that somewhere down the line the wow factor is missing. Okay, and that's where we need to now get deeper into the legal technicalities to find out why the claims of my patent application satisfy the requirements as mandated by the section 21JA of the Indian Patent Act. Other types of the rejections which we generally see in the final order is in relation to the section 3 of the Indian Patent Act. Okay, the section 3 lists out various non-patentable subject matters as per the Indian Patents Act. Okay, typical example is if your patent invention is relation to the pharmaceutical side, then you typically receive the section 3D rejection. If your invention is relation to the surgical or diagnostic treatment related method, then definitely you are going to get a rejection under section 3I. If you are into the software side and if your invention is somewhere into the software's application, then you are definitely going to get an objection of 3K, which ultimately gets converted into a rejection under the section 3K. So these are the typical examples in which the patent office rejects your patent application, citing that because of the applicability of section 3 in India, your patent application in India stands rejected. Other types of rejections, if we look at, is typically we generally receive objections which ultimately turns into rejection of the insufficient disclosure. So section 10 generally comes into picture, and we will see the language that the patent application description is too vague or incomplete for a skilled person to replicate the invention. So what does the learned controller try to communicate here is that you have failed to disclose the invention in detail, and that is why any person who is skilled in particular art of which is related to your field of invention is not able to replicate the invention on its own without any undue experiments. Okay, but having said that, listing of these rejections and providing reasons why the learned controller believes that the complete specification does not disclose the sufficient disclosure. Okay, another type of rejection which we have seen is in relation to the section 57 and section 59 of the Indian Patent Act. Many times we tend to amend the claims to overcome the prior art or to overcome the objections issued by the learned controller. So during these amendments, sometimes the controller disallow these amendments, citing that you are trying to broaden the scope of the invention in your newly amended claims, which is not permissible in the Indian Patent Act. Right. So third type of objection, if we look at, is that the applicant fails to update the Indian Patent Office on similar patent applications filed in the other countries. These are not the comprehensive list of rejections, but you consider that more or less you will definitely, if you have experienced the a rejection order, you will see that more or less the rejection order will include such type of rejections which ultimately led you to think that what is my next step now. Okay, so where I can now file an appeal. So let us now understand your statutory right to file an appeal against the final order of the Indian Patent Office. So when we discuss about the appeal proceedings, we come to the section 117A of the Indian Patent Act. So this section actually comes under the chapter Appeal of the Indian Patent Act, and this section actually lays down what are the various orders against which an appellant can file an appeal. So before we going further into the section 117A, it is important for us to understand about the Intellectual Property Appellate Board, which is the IPAB. Prior to the Tribunal Reforms Act 2021, any appeal against the final order or the decision of the learned controller goes to the Intellectual Property Appellate Board. But the Tribunal Reforms Act 2021 abolished the IPAB entirely, and the matters which were now pending with the IPAB were transferred to the corresponding High Court. For the Delhi Patent Office, the appeal proceedings now stands directly with the Honorable High Court of Delhi, and we are fortunate to have especially bench which is dedicated for handling the intellectual property related matters in the Delhi High Court. So all the appeals filed before the Delhi High Court goes to the single judge bench of the Intellectual Property Division of the Delhi High Court. Okay, so now let us, before going into the details, let us quickly go through the section 117A itself. Okay, so what does section 117A disclose? It discloses, the subsection 1 discloses, save as otherwise expressly provided in subsection 2, which is this: no appeal shall lie from any decision, order or decision made or issued under this act by the central government, or from any act or order of the controller for the purpose of giving effect to any such decision, order or direction. So subsection 1 of the 117A discloses that no appeal lies against the final order or decision of the controller except listed as per the subsection 2 of the section 117A. What does subsection 2 states? An appeal shall lie to the High Court from any decision, order or direction of the controller of the central government under section 15, 16, 17, 18, 19, section 20, subsection 4 of section 25, 28, 51, 54, 57, 60, 61, 63, 66, subsection 3 of the section 69, 78, subsections 1 to 5 of section 84, 85, 88, 91, 92 and 94. Apart from these sections, no appeal lie against the order or the decision of the controller under section 117A. What does subsection 3 now states? Every appeal under this section shall be in the prescribed form and shall be verified in such manner as may be prescribed and shall be accompanied by a copy of the decision, order or direction appeal against and by such fees as may be prescribed. So basically what does this subsection 3 states? That you will be filing the appeal in the prescribed formats which will be given by the respective high courts of the country. Whatever the fees, whatever the forms, whatever the other mandates which are imposed by the respective high courts, you have to comply with those requirements, and then only your appeal will be listed before the appropriate bench of the high court. Let's now discuss the subsection 4. Every appeal shall be made within 3 months from the date of the decision, order or the direction as the case may be of the controller or the central government, or within such further time as the high court may in accordance with the rules made by it allow. So basically you have 3 months to file an appeal against an order from the date of receipt of the order, first thing. Second is, in case if you are not able to file the appeal within 3 months, then you have to seek and leave from the respective high court. You have to seek approval of the respective high court to ensure that your appeal is listed before the respective high court. So if we see 117A, it says that there is a list of sections, and under which only you can file an appeal. Then we have the 3 months time period to file an appeal. So let us quickly go through the various sections or the subsections under which, if the order is passed and you are aggrieved by that particular order, you have the right to file an appeal under section 117A of the Indian Patent Act. So firstly we have the section 15, in which the controller requires amendment of the claims, and those amendments are not in accordance with the section 15. Okay, regarding the divisional applications, for example, the learned controller directs you to file a divisional application and you are of the view that there is no need of filing a division application altogether, so your application stands rejected in that case. Then you can still file an appeal, because the subsection 2 allows you to file an appeal against an order passed under section 16. Right? If post dating of the applications were there, then anticipation related, when the novelty issues are there, right, then the in case of potential infringement, section 19, if any order is passed under section 19, then you can file an appeal against the order of the controller. Then subsection 4 of this section 25 deals with the opposition to a patent after the grant. This is very important for us to understand. Okay, so if you are filing an appeal against an order in a pre-grant opposition matter, you will have a tough time to file an appeal under section 1117. Then other sections are like, if the inventor's names is missing, let's say, and you being an inventor, your name was missing, and the controller does not allow your name to be listed in the patent application, then you have a chance to file an appeal against the order passed under section 28, right? Apart from these various sections, if you look at this whole scenario of compulsory licensing, right? So this is the area also where you have the options to file an appeal against the order or the decision of the learned controller. So overall this list give you an enough idea that what are the various circumstances or scenarios under which you can file an appeal against the final order or the decision of the learned controller. The next question is how to file an appeal before the Delhi High Court. Section 117A empowers the Honorable High Court of Delhi to adjudicate the appeal related matters of the Delhi Patent Office. Okay, but we need to understand that apart from the patent rules, we also have to go through that we comply with the Delhi High Court Intellectual Property Division Rules 2022. Okay, so that our appeal is listed appropriately before the single bench of the Intellectual Property Division of the Honorable Delhi High Court. Whenever you are going to file an appeal before the Delhi High Court, it is officially named as a civil appeal, CA, that is C.A, civil appeal. Com means it's a commercial matter, IPD means intellectual property division matter, and PAT means it's a patent matter. So it's a civil appeal in a commercial matter which is a part of intellectual property division, and it's a patent matter. So CA, Com, IPD, PAT, all appeals are given this number, right? You are required to file a form 9 which is given by the Delhi High Court IPD rules 2022. This is needed to file an appeal. What are the various documents you need to file while filing the appeal is definitely synopsis and the list of dates are there, memorandum of appeal and grounds of challenge. This is the core of your any appeal. Okay, what are the various grounds under which you are going to challenge the final order or the decision of the learned controller? The impugned order, obviously the decision or the order which you are going to challenge. Okay, affidavit of the appellant, many times the statement of truth and all other documents which you need to prepare and file along with your appeal petition. All relevant documents from the Indian Patent Office record. For example, you can start with the first examination report FER, and in then you file your response to the FER. All documents whatever on which you have relied upon while preparing a response to the FER, right? And then if for example further hearing notice if it is given, then written submission whatever it was filed during after the hearing. Okay, so all these documents you will accompany with your appeal petition. Then another important thing which you need to understand is, for example, when the matter is between you and the patent office, right, then most of the documents which you are filing, which you are relying upon before the patent office, that will automatically becomes the part of the appeal proceedings. But when the matter is between you, the patent office is also a party, and there is also a third party. For example, in the post grant opposition, if you have filed a post grant opposition to any patent, right, then you need to disclose the details of any prior litigation pending between the parties considering the subject matter in dispute. Okay, so that becomes an important criteria when you are filing an appeal before the IPD of the Delhi High Court. Another important details which we need to discuss is that in pleading parties we have already covered, right, new evidence. For example, in the appeal matter, no new documents is generally taken on record, right? So documents are not the which are not the part of the IPO record are not generally considered, but if you intend to rely upon, then you have to seek a permission from the honorable court to produce to list the additional documents on record. So during the course of hearing of the appeal matter before the IPD, the filing of a reply by respondents is only upon the specific directions from the court. Okay, so the filing a reply is not mandatory, but if required, one can file the reply. Witnesses, the court may direct the appearance of a witness who testified before the IPO for any clarification also. So that's how a typical the requirements which you must fulfill while filing the appeal before the IPD of the Delhi High Court. So what are the timelines? As we are already now aware of the fact that filing an appeal must be within 3 months from the date of the controller's order. Okay, and in case we are not able to file within the 3 months, then any delay beyond the 3 months must be carried with the condonation of delay application, which must disclose the sufficient cause so that the Honorable High Court can consider that, oh yes, you were diligent, but because of the sufficient reasons as discussed in the condonation application, you were not able to file the appeal within the 3 months. So additional time taken by you is condoned. Okay, the court fee as of now, it is rupees 10,000 for filing an appeal in a patent matter, and the primary form which we have already discussed is the form 9, which is discussed in the IPD rules 2022. So once you file the appeal, it gets listed, then the response of the patent office is listened to, or any other party, contesting party response is also listened to. What happens finally? Okay, the High Court generally gives you several types of relief, and few of them are listed below. One is, it can set aside the impugned order and it can send back the order to the patent office for reconsideration. Okay, this is many times it's a most common relief. Okay, the rejection order is found to be unreasoned and cryptic. In most of the appeal matters, we were going through a catena of learned controller's decision in which in which the reasoning was absolutely silence. For example, if my patent application is rejected on inventive step, generally one line is being written in the order that the patent application in view of the prior art reference D1, the patent application or the claimed invention of the patent application lacks inventive step, and hence it is not patentable, right? No reasons are given. Okay, that is where in most earlier now the trend is getting replaced. Nowadays we are able to see that reasons are also being given by the learned controller why they are rejecting the patent application on the basis of section XYZ, right? The first relief for the patent appellant would be, it is setting aside the impugned order and the matter is sent back to the Indian Patent Office. Second is directing the grant of the patent also. We have seen certain cases where the Honorable High Court was pleased to grant the patent also. Okay, the Patent Office rejected the patent application. When the matter went for appeal, the Honorable High Court, after going through the submissions, after going through the response to the patent applicant, the Honorable High Court has granted the patent on the rejected patent application. Third type of relief is the allowing the amendments. The Honorable Court can permit the amendments to claim to overcome the objections as long as they don't add new matter, right? And the Honorable High Court has dismissed the appeal also. If the controller's decision is found to be well reasoned, the appeal is dismissed also. So it is not always that all orders of the learned controller are going to be dismissed. It is many times you may see that if you are not strong in your grounds, if you are not complying with the mandate of the Indian Patent Act, the Honorable High Court is pleased to dismiss the appeal also. So if I conclude the today presentation on section 117A, then few important points for us to understand is that a rejection from the patent office is not a final dead end, right? You must go through the decision, you must go through the final order in detail, find out where you feel that the learned controller has not has erred in its finding, and that's where your basis for filing an appeal gets started. The appeal process under section 117A is a critical right for the innovators. If you do not appeal, then obviously the final order will be against you always. But if you go through the order in detail, if you are able to find out the issues in the final order, then the section 117A provides you an ample opportunity before the respective Honorable High Courts to challenge the order and get success in getting a patent application granted. The Honorable High Courts as a vital check on the patent office decisions, ensuring they are based on the sound legal principles. Okay, and a well prepared appeal is a powerful tool in your IP toolkit to protect your innovation and turn a roadblock into an opportunity. And I hope with this video you are able to understand briefly about the appeal process as of now after the abolishment of the Intellectual Property Appellate Board, and how you can file the appeal before the IPD of the Honorable Delhi High Court. And don't forget to like this video and share this video with your friends or other stakeholders who are facing a rejection order or who are going through a tough time. And if you have any specific questions, if you have any specific comments, feel free to write to us at info@nyaytantra.com, or you can WhatsApp to us also. We will try to respond to your specific questions or comments as soon as possible. And don't forget to subscribe to this channel. This will boost up the morale of the team who is working hard to generate such videos where we try to simplify the legal issues into simple language for understanding. We have also created other videos on the Patent Amendment Rules 2024. You can go through the list of these videos in our description box of this video. And thank you very much for going through this video. Jai Hind.